So we've got a super interesting exchange set up for today. We're joined by Taryn Blignaut. He is the founder and chief legal ninja at Legal Ninjas. Welcome, Taryn. Thanks for joining us.
Thanks so much. Yeah, so I'm
We
Taryn. I'm from
we
Cape
don't
Town.
have you on audio, Taryn,
Oh,
unfortunately.
oh, okay.
No problem. We'll give you actually we do.
Okay. I'm Taryn. I'm from Cape Town, and I'm the founder of Legal Ninjas. Basically, we're a legal consultancy. We service clients online only, and in this way, we can keep the costs down. So the whole aim of Legal Ninjas is to provide quality legal services to SMEs that may not necessarily be able to afford the big fancy law firms. And yeah, all of our attorneys are like in-house legal counsel for big corporates. So we have years and years of experience helping companies with all their legal needs, and now we're just applying that knowledge to SMEs and helping them with all their legal and compliance needs. So Thomas, should I go ahead and share my presentation?
Yeah, sure. So I think just for everyone's listening, as you know, Lula's super dedicated to helping SMEs grow and succeed. From our point of view, inviting Taryn today is interesting because I think legals are a very daunting part of being an SME. You kind of feel like the big corporates have lawyers and they know the law and what's going on and how to manage that. And I think legal services are something that we hear from our customers that feels a little bit inaccessible or confusing at times. And so today, while our kind of, I know the positioning of the episode today is, what do you do when clients don't pay you? We know that that's a massive topic for a lot of our customers. SMEs on average wait double the amount of time that the corporates do to get paid if they're providing terms to customers. And that's just one example. And so this idea of when clients don't, or when your clients don't pay you as an SME, how can you use the law? How can you use contracts to kind of safeguard your interests as a business? I know, Taryn, your presentation here goes well beyond that, but yeah. So just positioning for our customers. I mean, really keen to hear from you today. This is a burning topic for a lot of our customers, and so what we'll do is Taryn's going to take us through this presentation, give us quite a lot of information. So I mean, yep, kind of full attention. Get that cup of coffee in, all your focus ready. This is very interesting. And then Taryn will end with a bit of a Q&A. So we will open it up. So please save your questions if you've got them for the end. We'll open up to a Q&A. You can drop a question in the chat, or you can kind of raise your hand and we'll let you ask the question at the end. So thanks very much, Taryn. Over to you.
Cool. All right, so I thought I'd start with just a brief introduction of contracts, just to give you a high-level overview, and then we'll go into the more detail around, safeguards around protecting your business against non-payments by clients. So firstly, when we're talking about business contracts, I get a lot of clients that come to me for assistance when something goes wrong. And then I ask them, please send through your contract that you signed. And they say, oh, no, we didn't actually sign a contract. It's all just verbal, like we verbally agreed this and that. So my first point to make is please do not rely on verbal arrangements. The first rule of thumb with businesses is get it written down. It forces you to really agree to all the terms up front, and make sure that you have a mutual understanding of how the relationship's going to work, what the obligations are on each of the parties, how much you're getting paid, when you're getting paid. All of that detail needs to be set out in a written contract. So firstly, a written contract, it's basically a legally binding agreement between at least two parties. It can be multiple parties. You can have a tripartite agreement between three parties, for example. And in that agreement, each party commits to doing and possibly also not doing certain things. It needs to be clear what the rights and obligations are of both parties. So you have the right to be paid, they have the right to receive your services, and you put in the detail of exactly what those services are, how you're going to perform them, where you're going to perform them, when, etc. All that detail needs to go in there. And this creates a document which you can then use to enforce those rights and obligations. So it provides clarity and mutual understanding. This will help you to avoid disputes at a later stage. Because if you've just got something, on an email or verbal or on a WhatsApp, it's very difficult to then rely on that later on if something does go awry, if you don't get paid, what are you going to even do? What can you show a court to say that this is what was agreed? So yeah, that's a very vital point that I want to make. And then in terms of dispute resolution, if there is a dispute that arises between the parties, that's also something that you need to cater for in the contract itself. So you would have a dispute resolution clause, which I would suggest you definitely cater for mediation and arbitration, because as you may be aware, in South Africa, the courts are a bit of a hot mess, to be honest, and they are extremely expensive to go to. So you need to hire a fancy lawyer to take you to court. It costs up to like hundreds of thousands of rand to get disputes resolved in the High Court, for example. So you really want to cater for alternative dispute resolution in your contract, which will actually allow you to afford to go after someone who doesn't pay, for example. And then just another note on your contracts, having business contracts is also vital if you ever want to like sell your business down the line, because an investor is going to want to see that you have all your ducks in a row, that you have these business relationships sewn up tightly in a written agreement. And it also just shows that you take your business very seriously, you're professional, and yeah, it's really a good idea from that perspective as well. Okay, so what makes a contract legally binding? So having something written on a napkin, that's not going to mean anything. If you have a little notepad and you guys sign that, not great either. So I just want to take you through exactly what the requirements are to make your contract legally binding. So firstly, something to note is that you need to be very clear on who the parties to the contract actually are. Is it someone in their personal capacity? Is it a company that you're dealing with? And if it is a company that you're dealing with, who are the key representatives from that company that you're actually going to be like liaising with on this business relationship? And then, if it is a company, if you have your own company, you need to be sure that the person signing and entering into the agreement actually has the authority to do that. So from your perspective, you need to make sure that you have the authority to bind your company to that contract. And this is usually done by way of like a resolution from the board of directors. So that's also just something to be aware of. And then, yeah, the terms of the contract need to be very clear and as detailed as possible. Many people come to me and they say, "Oh no, I just want a one pager." And that's every lawyer's nightmare, because it's usually impossible to, put everything that needs to be in an agreement in onto one page or even two pages. This is why contracts usually are quite lengthy, and it's intended to be like that, because you want as little room for disputes as possible. You want everything to be in there so that there can be no confusion as to what has been agreed. And then obviously the purpose and the terms of the contract need to be legal. So you can't contract out of what the law actually says. So you can't say, oh no, labor law, actually I hate what the labor regulations say. I'm going to just create an employment contract that says I'm going to pay you below minimum wage. That's illegal and that won't be enforceable, for example. So that's also something to note. And then in terms of formalities of contracts, most business contracts, you literally just have to sign it for it to be binding. There are certain other contracts, like, when you sell an immovable property, for example, where you have to actually go and sign in person. It needs to be initialed, witnessed. It needs to, have all those formalities in place for it to actually be binding. But for most contracts, you don't even need it witnessed. You don't need to initial every page. Those aren't actually legally required. You just have to sign on the dotted line. But make sure you sign it, because I've also had clients come to me with a lovely draft contract wanting to enforce those terms, but it was never signed. So then it's meaningless. So yeah, that's also something to note. And then, yeah, there are certain types of documents that people try and rely on, but they aren't actually meant to be binding. So, for example, an MOU is often something that's used in the business world, but this type of document is just a memorandum of understanding. So, it's kind of the document that you put together before you enter into the actual contract. So, that's like to start discussions, to sort of ignite the business relationship, but it's not really legally binding and enforceable. So you've also just got to make sure that the contract that you're signing, there's like a clear intention to bind the parties to that. And then these are just sort of the types of typical contracts that we see in the SME world. So as you can see, there's many different contracts that every business would typically need. An employment contract for any employees that you hire. If you use subcontractors or, service providers, freelancers, that type of thing, where it's not really a fixed like employment relationship, then you're probably going to want to use an independent contractor agreement. A services agreement where you're selling or procuring services. Then if you're selling things online, you would usually use terms and conditions, setting out, your returns policy and when you're going to refund a client and all those good things. NDAs are often used to secure confidentiality, often before you enter into the main agreement. Like if you're wanting to get interest in a deal, for example, but you don't actually have a business relationship with this person yet, and there's no contract in place which already binds them to confidentiality, then you would use an NDA to make sure they're not going to now steal your idea and run away with it, or breach your confidential terms and tell their best buddy who's your competitor, etc. Then you've got partnership and collab agreements for businesses that want to do collaborations together. Shareholders agreements are vital if you have a business where you have more than one owner and you want to regulate which owner is doing what's going to happen if an owner dies, all these types of things that you might not think of when you're forming a company, but actually you have to think through all those steps, like who's going to do what, who's responsible for funding, all of those things need to be put down in a shareholders agreement. And then obviously if you have office space, you might come across a commercial lease agreement. There's all types of agreements to do with selling shares in your company, buying shares, getting loans for financing, selling your business, and get all sorts of things like that. So that's also a whole array of financing agreements. So as you can see, lots of different types of contracts, and very important to actually have these in place to protect your business and secure your intellectual property, your right to be paid, all those sort of rights. Okay, so these are some contractual terms that I would recommend thinking about to prevent a situation where you aren't getting paid for the services that you're providing. So firstly, it's very important to include very clear and detailed payment terms in your contract, and not just, the vague amount that you're going to get paid, but also, how's that going to work? Are you going to send an invoice every month? By when will that amount be payable? Is it a 30-day term? Is it a 60-day term? Do you require upfront payments every month? Is there VAT applicable? Are you allowed to expense certain things, like if you have to travel? Um, then for longer term projects, where you're actually going to be doing work over a period of many months, for example, you might want to include different milestones where you are getting paid. So you're not going to be working for months and months on end and then waiting for your payment right at the end of the project, but you rather stagger it. So say you get 25% upfront, 25% on a certain deliverable, and then the balance at the end. In this way that you can ensure that, by requiring that upfront payment, that the client is taking it seriously and they're going to commit to their obligations. And then in terms of a services type agreement where you're providing services and you're getting paid monthly, I would suggest including a clause which allows you to down tools if they don't pay you on time. So for example, if you're on a 30-day term and the 30 days has passed and you've sent reminders to the client to pay you and they're still not paying you, you can then say, okay, guys, I'm stopping all work on this project until I get paid. And the contract then legally entitles you to do that without being in breach of your own obligations. You might also want to include penalties for late payments. So say you have to, switch off a system for the client to no longer be accessing the services. Now you might want to actually charge a penalty to reconnect that service, for example. You also want to charge interest on late payments because you're losing out on that money sitting in your own account. And then another clause that's very good to include is a clause which says that at any time a certificate signed by the director of the company noting the amount owed is actually like proof of the indebtedness of the claim, because this creates like a liquidated claim, which will help you later if you do need to go the legal route. For example, you could apply for a summary judgment in the High Court for the amount owing, because that's like proof of the amount. And they have to then come and say why it's not correct or whatever. So that's another one that's good. As I said before, the alternative dispute resolution clause is very important because of the fact that litigation is just incredibly expensive. If you're talking about transactions in the millions even, I think arbitration works well. So it's not like this is just for small amounts. I think this is vital for all types of contracts. And then another thing you can put in your contract is to agree, if you do go the litigation route, you can agree to the magistrate's court being able to determine the matter, even if it exceeds the typical magistrate's court monetary jurisdiction, because usually there's a limit on what the magistrate's court can determine, and then it has to go to the High Court. But the minute that you go to High Court, it's like hundreds of thousands of rand for litigation. So that's also a clause that you can put in. And then if you're dealing with huge transaction values, or you've done a DD on your client and they're actually like a really new business, you're not really sure if they can even afford this type thing, then I would suggest you might even want to procure guarantees or suretyships from the actual directors of the company. So a guarantee is where the holding company of your client would secure payment. So they say, okay, if the client doesn't pay you, then we'll pay you. And so it's like a juristic person version of a suretyship. And then a suretyship is where the actual people that are running the business, the directors, say the same thing. They say, if the client doesn't pay you, we will then pay you. So that really gives a lot of comfort. It means that you can then go after the directors for failure to pay, etc. Okay, and then obviously, if you are going to need to go the legal route, you're going to rack up costs, right? So you're going to have to get a lawyer, it's going to be expensive. So having a clause in your agreement which says that any legal costs that you incur in having to collect arrear payments, they have to also pay that. Because often the legal costs can rack up to the same amount as the amount that you're actually claiming. So that's also very important. And then if you are going to be doing some sort of service where you're creating IP for the client, you also want to then include a clause that says you retain ownership of that intellectual property until such time as you pay it in full, because then they actually legally aren't allowed to use any of that material until they've paid you. So always be thinking about, what could go wrong in this relationship. As nice as the people are, I've seen it time and time again, start off buddies and then things go pear-shaped. So you really do have to think of what could go wrong in this relationship and how do I best protect my interests against what could go wrong. Obviously, I'm also going to say hiring an attorney is always a good idea, but I know that, we aren't the cheapest. So these are just tips to keep in the back of your mind if you maybe don't have the budget to go to a lawyer to help you draft these things. As much as AI is, helpful in starting with first drafts of contracts and stuff like that, it really isn't at the point where it's going to be enough for, protecting your business. So just think about that as well. ChatGPT is evolving, but it's not quite there yet. Okay, and then practical steps to be taken. So when you are dealing with a new customer, you don't know anything about this customer, it is always a good idea to do some sort of due diligence on them, especially if the transaction is, a larger one in value. So maybe you want to even require FICA documents of the directors so you know who you're dealing with. You might want to Google the company. Sometimes you can find stuff on Google, even, case of fraud or some lawsuit or something, and then that gives you like an inkling. Maybe these people aren't great to be dealing with. You could also even do credit checks, check online reviews, all those sort of checks just to make sure that, you're dealing with a counterparty that seems to be reliable at least. Then obviously requiring deposits for work to even begin is always a good idea. So that really mitigates the risk of non-payment if you say, look, we require 50% deposit up front. That shows you that they're serious about the commitment to pay you and that they actually have the money. For monthly retainer type work, obviously, ideally, you want to invoice upfront every month because usually you would have a 30-day term for payment. So that means that by the end of the month, you've been doing all this work, by the end of the month, you'll actually get paid for it. Otherwise, you have to wait another 30 days at least. And then if there is any late payment, you have to act very promptly with that. You want to create boundaries with your clients. So, in the same way that you are expected to work in accordance with the contract, they're expected to pay in accordance with the contract. So sending clients reminders, don't be scared to do that and jump on it as quickly as possible. Okay, and then document everything. So keep your agreements, keep your emails, all invoices, proof of the work that you've done, etc. Because if you do need to go the legal route, you're obviously going to need paperwork to send to your lawyer or to assist you when you go to court that shows why you are owed this money. And then I've had other clients come to me where they actually want to re-engage with the client and they say like, oh yeah, they actually didn't pay our last time, but they're such a big client and I'm just like, no, 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 no. Walk away. If someone's shown you who they are by not paying you, like, don't do business with them again. It seems obvious, but please just don't do it. Okay, and then for businesses selling goods rather than services, in terms of movable goods, ownership passes on delivery. So you really want to be paid in full before you deliver the goods. Um, this is why most online stores you have to pay upfront on when you order. Um, and obviously don't ship the products to the clients before the payment is actually cleared and is in your account, because there's so much fraud out there, so many people sending pops, but the proof of payments are actually just made up. So this is also a risk for when you're selling goods, because once those goods are shipped, it's going to be very hard to do anything if you don't actually get the payment. And then ensure that you have a clear returns policy in your terms of service or terms and conditions on your website. And it obviously needs to comply with the Consumer Protection Act, but it needs to be very clear about, the situations in which you'll consider refunds and returns and all of that stuff. And then be very wary of any consignment arrangements for goods. Because obviously this is very risky when you're handing goods over to a store, for example, to sell your products. How are you going to know, what happened to all those goods if they're not having to tell you that detail? So you're going to be invoicing for goods as they sell, but for all you know, half the goods have disappeared. So you really want to have a contract in place for that sort of arrangement and ensure that regular stock takes are taken for the invoicing of goods sold, and that the store itself is liable for any stock theft, for example, or damages. They need to have business insurance in place to secure the actual stock. And you obviously want to make it clear in the contract that you retain ownership over those goods until they're sold, and you have the right to inspect and audit, and also collect the stock if things aren't selling quickly enough, or they're going to expire if they're not selling, etc. You want to actually say, look, this isn't working out. I want to collect my stock. So those are just good things to note there. And then I've just set out a contractual framework for when you're drafting an agreement, the good clauses, sections to have in your contract. Parties to the contract need to be very detailed. The goods and services also obviously very detailed. You can't just put, I'm going to be doing IT services. I mean, what the hell does that mean? You need to say the exact things that you're going to be delivering for this client, because otherwise you have the risk of scope creep, where suddenly the client goes, oh no, but I understood that you're going to do this and this and that extra. So you really need to protect yourself by putting in the exact detail. And then yeah, the from the other side, if you are procuring services from someone, you need to also provide for, monitoring those services. What if they're actually doing a terrible job? You need to say, okay, well, if we're not happy with the services, we're going to have like a monthly meeting and discuss any issues, and you need to remedy the problems within 14 days, etc. So just think of, again, what can go wrong. And then duration and termination. So this is obviously to say, when does the contract actually start? When does it kick in? Because obviously you sometimes will sign an agreement potentially even months before the actual relationship is going to kick off. Is it for a fixed period, or is it just that, it's ongoing until someone terminates? How much notice is needed to terminate? What are the procedures and effects of termination? What needs to be done when termination occurs? Do you need any level of cooperation from the other party to hand over to a new service provider, for example? And then the pricing and payment terms, as discussed, they need to be very detailed. An agreement actually isn't valid unless the price is either fixed in the contract or is at least determinable in terms of the contractual terms. So that's something very, very important to remember. You can't have an agreement to agree. So you can't say, oh, we'll just decide in a few months' time how much is payable. That's null and void. So it needs to be very clear. Invoicing, when is payment due? Is interest charged? You know, do you have the right to down tools? What happens if the party disputes your invoice? What is the procedure then? All of that needs to be in there. And then obviously you have a clause setting out all the obligations of each party. What do you need from the other party to be able to deliver your services, for example? Do you need access to documents and information? Do you need to actually have access to their offices? All of that goes in there. And then Poppy is a favorite one. We all love Poppy, don't we? So Poppy compliance is something that every business needs to be aware of. And it's always a very good thing to include a Poppy clause in your contracts to say how you're going to collect that party's information and why. And also just mirrors your privacy policy, because you should have a privacy policy in place. So it just kind of gives the high level overview of how you protect the information, what purposes you're going to use that personal information for. All of that goes into your little high level Poppy clause. And then confidentiality is usually something that all businesses want to protect. So having a confidentiality clause that's almost a high level version of an NDA, that's also a good one to put in your contracts. And then intellectual property, if you have any IP that's going to be disclosed, shared, created under the agreement, you want to detail what party owns the IP. You know, do you cede the intellectual property to the other party on payment? Yeah, that needs to be dealt with. And then, as discussed before, breach of the contract and dispute resolution needs to be catered for. Having the procedures set out in the agreement means that it's very clear when some dispute arises what you need to do to resolve that dispute. Otherwise, you're like, what next? Liability. This is the lawyer's favorite clause in every contract. So who is liable for what, and is there any limitation on liability? So to protect your own business, I would suggest that you limit liability to direct losses only. You don't want to be in a situation where you are liable for indirect consequential loss of something going wrong, like you failed to do something and now the other business has lost profits that they could have earned if this had not happened. I mean, that opens you up to so much more money being lost, an unclear amount, meaning that you have to litigate to determine the amount. It's just really not a good idea. So that's something I recommend for everyone. And then you might even want to include a liability cap. So you say, no matter what, I'm only liable for the maximum amount that my business insurance pays out, or an amount of all the fees you paid me over the last year, or an amount of 100,000. You can come up with whatever the cap is that makes sense in the scenario. But yeah, having a fixed amount in mind that your maximum worst case scenario of what you're going to have to pay if you mess up under a contract, that's always a good idea. And then obviously you need to potentially send notices to the other party during the term of the contract, like legal notices, or if you need to notify them that you dispute something. So you need to put in who you're going to be sending that notice to and where it needs to be sent. Nowadays, we obviously just send things via email, and that's absolutely fine. So if you see a contract that's still referring to facsimile, please just delete that. And then the signature page, vital, please make sure it's signed. A draft contract is worth absolutely nothing. So just don't go there. Make sure that you get the countersigned version back from the other party and that you file that away. Thomas, how are we looking for time? I don't want to keep rolling on if we're getting close to the end here.
No, I think we're still good on
Okay,
time. I think we've
I'll
been
just do this
able to.
one last slide and then we can do the questions.
Brilliant.
Okay. All right, so this is just tips on negotiating contracts. So no matter who you're dealing with, whether it's a small guy or a huge corporate, having worked in massive corporates before, um, you know, you shouldn't feel like you're going to just be bulldozed and you must just accept whatever they send you, because often big corporates will want to use their own standard template. And that already puts you at a disadvantage to some degree, especially if you don't have legal counsel, because now you've got to think, oh, like, what changes can I make to this? Do I even understand everything? So firstly, have your own template contracts that you try and get to use for your contractual relationships. If it's a non-negotiable and they say, no, we have to use our agreement, okay, fine, but then you need to actually look at those clauses. And if you say, like, oof, this is really not good, this is something I can't accept, then you must feel free to go back to them and say, sorry, this isn't going to work like this. I need to change this clause for this reason. So know your non-negotiables up front. And then when you request changes or the other party requests changes, always just think like, what are the risks to my business if I accept this change, or if they don't accept the change? Is there a way to maybe compromise on something? Um, if you want upfront payments and they say absolutely not, we're paying you at the end, then maybe you compromise on a 50-50 where you get paid 50% upfront and 50% at the end, for example. And if something is just a nice to have for your business, then you know that that's like a negotiation tool that you can say, okay, well, we don't actually really need that. That's just a nice to have. So we'll get rid of that thing, but in exchange, we want this. So it's all about coming up with a fair agreement that is clear, it sets out all the detail relevant, but you're not feeling like you're being bulldozed and bullied into an arrangement which is going to actually put your business at risk. Um, and also when the counterparty comes with changes, think about why do they want that change made. And if it's unreasonable, then feel free to reject it. And yeah, if you are countersigning the signing the counterparty's contract template, and they just say this is our standard contract, there's no room for negotiation, then just say to them, look, there's no such thing as a standard contract. I'm not accepting these terms. Don't feel afraid to go back and negotiate, because you really do need to set the terms to a reasonable degree upfront, because trying to change a contract later on is a complete nightmare. So rather, like, I know it's hard to walk away from potential business, especially big business. But if you're not comfortable and you wouldn't agree to this for a small client, then why are you agreeing to it for a big client? Like, it really could put your business in jeopardy to agree to terms which you're really not happy with. And then obviously try not to get emotional about things. Keep things professional, even if the counterparty is being totally unreasonable, disrespectful. Um, Try and keep things professional. And if it really gets bad, then see that maybe as a red flag of how the relationship's going to be going in the future. And yeah, if you get that horrible gut feeling, then you might want to consider walking away. But yeah, just be open to compromise, but not at the point where you are risking your whole business for this one client. And then obviously another thing that's worth noting is please ensure that you have business insurance to cover your liabilities under contract, and also anything that could go wrong. If you mess up something under a client agreement and you need to pay them, if something goes wrong with your stock and it's lost, etc., no matter what type of business, usually having some sort of insurance. And if you a professional service provider, having Professional indemnity cover is also a good thing, for example. You know, we're not perfect. We do get things wrong from time to time. So you just need to think of all those potential risks to your business and how you can best protect yourself against those. Because if you don't, your business might not be sustainable in the long term. Okay, I think that's all.